Good evening, everyone. My name is Ben Schwartz. I serve as the law clerk to Justice Peregrinos of the CNMI Supreme Court, and also as the coordinator for the 2022 Summer Pre-Law Program. If you are not familiar with the Summer Pre-Law Program, it is a program organized by the CNMI Judiciary, which aims to support locals who are thinking about a career in the law. It offers several weeks of intensive law classes that are designed to simulate the first few years of law school. In order to do this, we fly out professors from the mainland all the way here to teach these classes. And in order to also allow the broader community a chance to interact with the professors and to learn about the law themselves, we also organize this Law in the Community lecture series. This is the second of 4 public lectures. The next one will be July 5th at 6 p.m. here at the American Memorial Park Visitor Center. And the 4th one will be on July 7th at noon at the Guma Justicia and Suzuki. The Summer Pre-Law Program and the Law and Community Lecture Series have been very generously supported by the Northern Marianas Humanities Council. We thank the council for their support. At the end of the lecture, I'm going to be distributing a survey on behalf of the Humanities Council to get your feedback about the program. Now, without further ado, please give a warm welcome to a returning daughter of this island, Associate Professor Eun Hee Han of Georgetown Law School.
Thank you, Ben. Hello and welcome. My name is Eun Hee Han, and I'm an Associate Professor of Law, Legal Practice at Georgetown University Law Center in Washington, D.C. I also identify as a local. I grew up here, which makes me very obnoxious and difficult to deal with every time we have mangoes on the mainland. You can ask my husband. It's terrible. I am thrilled to be back here and speaking before you today, and I thank you for the opportunity to do so, with an especial thanks to the Northern Marianas Humanities Council, the CNMI Bar Association, the CNMI Judiciary, and CNMI Historical Society. Thank you also to Dean Rose Quizon Villazor, who paved the way this past Tuesday with her public lecture, and will throw you with another one this upcoming Tuesday on the insular cases and citizenship. And thank you for everybody who came to hear me speak, especially my family, my mom who's right there, and Liberty, who is paying as well to friends who've come to provide support. Okay, now this is feeling a little bit like an Oscar speech, and I haven't actually done anything, so I'll dive in. My lecture today is about stories and accent. Specifically, I want to cover a few ideas. I want to review what critical race theory is generally. I want to talk a little bit about one method used by the critical race theorists, counter storytelling. I want to talk about how one scholar, Mari Matsuda, was part of the group that founded critical race theory, used the CRT method of counter-storytelling in a groundbreaking way to examine Title VII law and its application to national origin discrimination based on accent. I want to talk about the current state of the law, as well as ongoing issues in the public sphere. And then finally end, if we're not, if it's not tomorrow morning by then, with what we can do as individuals in society, including those of us who are engaged directly in the law and legal practice, and those of us who are members of the broader public. I'll start with critical race theory, with, again, thanks to Dean Quizon Villazor, who gave us the history of CRT, its contributions to legal scholarship, and its tenets during this past Tuesday's lecture. Essentially, CRT began as a scholarly movement in law that spread to other fields of scholarship. CRT is, according to my Georgetown colleague Janelle George, a practice of interrogating the role of race and racism in society. According to Professor Matsuda in her article, which I'll discuss, it is an attempt to develop a jurisprudence, which is a theory of law, that considers the role of race and racism in American law and works towards the elimination of racism in law. CRT as it works now recognizes that racism is not a bygone relic of the past, but instead that race-based negative impacts continue to affect people of color in America. And I think I heard someone say over there, in essence, it's using your head, and I don't disagree. There are a few key tenets in CRT, which again, Dean Cuizon-Villazor discussed on Tuesday, so I will not go into them into too much detail at this point, but I'll just briefly review them. One, racism is ordinary and systemic in nature. It simply exists. Two, interest convergence. This is the idea that minorities gain only when the majority's interests converge with theirs. Three, that race is socially constructed. All the things that go around race is socially constructed and matters. Four, a rejection of colorblindness, the idea that colorblindness is flawed and doesn't account for real racial imbalance. Five, intersectionality, that race, class, gender, disability, and other forms of inequality can combine to impact inequality on the whole. Six, anti-essentialism, that race does not reflect inherent biological differences. And seven, that narratives and storytelling are essential tools to uplift marginalized voices. Overall, that means to critical race theorists that laws reflect racial power, even those laws purported to be neutral, and that all of that should be examined. CRT acknowledges that racism is embedded, even if unintentionally, into U.S. institutions and structures, which includes codified law and the way in which legal decisions are made. Part of the work of CRT scholars is to bring to light how racism might be embedded into what we accept as current law. And this means to activists that laws might be changed or critiqued to undo racial imbalances. Mari Matsuda was one of the founders of critical race theory. She's a scholar, a teacher, an activist, and as I recently found out, a musician. Professor Matsuda is from Hawaii and was my professor in my first semester when I attended Georgetown Law. She was the only person on campus who had any idea what I was talking about when I said I was from Saipan. And so I thought it was fitting to use her still relevant work as a foundation and inspiration for this lecture. In 1991, the Yale Law Journal published Mari Matsuda's groundbreaking piece, Voices of America, Accent, Anti-Discrimination Law, and a Jurisprudence for the Last Reconstruction. In the piece, Professor Matsuda discussed how Title VII anti-discrimination protections are applied to discrimination claims brought by employees against employers when the claims involve accent. The article is self-described as reflecting a use of critical race theory methods, positivism, sociology of law, and postmodernism. Essentially, what Professor Matsuda does in her article is she tells the stories of the people in the Title VII cases, which again is a method used in CRT. And she includes other frameworks such as linguistics, emotions, and discussions of unconscious bias. This inclusion of other frameworks is also a method used in CRT. Many of the issues that she brought up are still salient today. But I want to do a little bit more table setting before we can get to some of those issues. So one thing that's important for us to understand before we get into some of those issues is the foundational law itself. Title VII of the Civil Rights Act of 1964 is still in force. And essentially it prohibits employers from refusing to hire, firing, failing to promote, or otherwise adversely impacting employee status because of an employee or a potential employee's race, color, religion, sex, or national origin. National origin has been most closely tied to accent to date. This provision might seem fairly clear-cut. Employers simply cannot discriminate against employees based on their membership in one of these protected classes. However, an employee or would-be employee, somebody who's turned down for a job because of their membership in one of these classes, has a long and arduous process ahead of them in order to trigger the protection and gain relief. There are many stopping points along that process. First, something must happen, and then the employee, which I'm using as a shorthand for the employee or potential employee, has to realize that this is a potentially triggering event and realize that there's potential recourse and be able to take advantage of the channels for that recourse. Then they have to figure out how to proceed along those channels and work with the EEOC by providing information about the alleged violation or filing a charge, which then has its own formal requirements. Then the EEOC notifies the employer of the charge. So the employee or potential employee has to understand and be okay with the employer knowing about the filing of the charge and the potential investigation, which has ramifications for the employee or potential employee. The EEOC then investigates, which can take months. While it investigates, it might encourage the parties to settle or mediate, which is another stopping point. And then finally, if at some point the EEOC determines that there is reasonable cause to believe there has been an unlawful employment practice, the EEOC may still encourage some form of informal resolution like conciliation. If that doesn't succeed, then the EEOC can bring suit or provide a right to sue letter to the individual to allow the individual to sue in federal court. So all of this happens before the individual even gets a chance to go into federal court. Once the claimant, the employee or potential employee, gets to federal court, they still have an uphill battle. They have to prove their case. In federal courts, Title VII claims are analyzed using a three-part framework under an established case, McDonnell-Douglas versus Green. The employee has to establish 4 things as part of step 1 of that framework. They have to show that they belong to a protected group. They have to show that they qualify for the job in question, or somehow show other circumstances for which they deserved what they wanted to obtain. They have to establish that there was an adverse employment action. And then they have to show circumstances that support an inference of discrimination. All of that is step 1 in federal court after this process. If the plaintiff establishes all of those pieces, then the employer can articulate a legitimate, non-discriminatory reason for the adverse employment action. Then the burden goes back to the employee. If the employer has established or articulated some legitimate, non-discriminatory reason, then the employee has to prove that a reasonable jury could infer that the employer's given explanation was pretextual, and that this pretext shielded discriminatory motives, basically that they lied. That's all determined by a judge now, before the case gets to a jury. And this is all, as you can start sort of imagining, a pretty high bar. A vast majority of Title VII claims fail. And as you can imagine, the stories told in these cases are influenced by employers, many of which, some of which or many of which, may have more resources than the employees. That's what gets us to storytelling and really counter storytelling. Many of the Title VII stories are employer stories. Some parts of those stories might be stock stories. A stock story is the narrative you default to when something ambiguous happens. Think the story that we fill in when we hear prompts such as, the two of them laughed together over there. Or, he didn't make eye contact with the police officer. He acted nervous in the airport. She wasn't forthright about a different situation. Or, they speak in a certain way, therefore X. As my colleague and good friend at Georgetown, Sherry Lee Keene, has written, stock stories work to maintain the status quo, presenting a dominant narrative that often goes unchallenged. Keene in her work has also cited Leanne Bell, who wrote, underneath the stock stories are numerous teeming stories that talk back to the stock stories, that challenge them, that speak otherwise. That's part of what Professor Matsuda accomplishes in her article, that telling of those counter stories. I won't go through the entire article, but what I do want to pull from it today are two of the stories that she tells about two major Title VII cases. The first is Manuel Fragrante's story. Professor Matsuda was uniquely suited to tell this story, given she argued the case before the U.S. Court of Appeals for the Ninth Circuit as volunteer appellate counsel. Part of my aim in retelling this story today is to keep it alive as a counter-story. Another is to help us understand that it is not, in fact, ancient history. According to her telling, Manuel Fragrante was born and raised in the Philippines. He learned English while in school in the Philippines and earned a university degree in law. He volunteered from Manila to serve in the American military in the Vietnam War and received military training on multiple bases on the U.S. mainland in English. As he got older, his daughter moved to Honolulu, and Mr. Fragrante immigrated there as he approached retirement age, becoming a naturalized citizen. He was American. He wanted to keep working. In 1981, Mr. Fragrante decided to apply for a posted job as a clerk at the DMV. He took a civil service exam with over 700 other applicants and received the highest score. 350 other applicants failed the exam entirely. The remainder scored lower than Mr. Fragrante. Mr. Fragrante was then placed on a list of 15 eligible applicants, certified to the DMV, and was ranked number 1 on that list. He interviewed for the position of clerk at the DMV and was rejected after a 10 to 15-minute interview. Mr. Fragrante's rating sheet completed by the interviewers, a supervisor and a secretary, showed a low rating in speech. Written comments included difficult manner of pronunciation, pronounced and heavy Filipino accent. The administrator in charge of hiring recommendations said, because of his accent, I would not recommend him for this position. Mr. Fragrante brought a case against the city and county of Honolulu, alleging disparate treatment under Title VII on the basis of national origin, accent, and race when he was denied employment. At trial in the district court in Hawaii, a linguist testified on behalf of Mr. Fragrante that he spoke grammatically correct standard English with an accent, and that any non-prejudiced speaker of English would have no trouble understanding Mr. Fragrante. Professor Matsuda notes in a footnote in her article that, in fact, those present in the courtroom, including the judge, opposing counsel, and a court reporter, understood Mr. Fragrante's responses to questioning. During a half day of Mr. Fragrante's testimony, the judge had communication difficulty only once. The witnesses for the defendant, the city and county of Honolulu, testified the DMV is a place of high stress, short-term interactions, and that communication is the essence of the job. The employer asserted that Mr. Fragrante's accent would impede his job performance. The district court took that at face value. It determined that there was no discrimination based on race or national origin, and that Mr. Fragrante's rejection was based on a reasonable policy because the ability to communicate clearly and effectively was a bona fide occupational qualification for the job of a DMV clerk. The court found Mr. Fragrante has extensive verbal communication skill in English, but a difficult manner of pronunciation and a military bearing, and that some listeners would stop listening to Filipino accents, resulting in a breakdown of communication, despite also acknowledging that Hawaii is a socially and linguistically complex community. Mr. Fragrante appealed to the Ninth Circuit Court of Appeals, which affirmed the district court's decision. The Ninth Circuit highlighted the district court's note that Mr. Fragrante has a difficult manner of pronunciation and determined that others had superior qualifications for the tasks of a clerk. The case was appealed to the Supreme Court, but denied cert, so it stopped there legally, but Mr. Fragrante's story was kept alive by Professor Matsuda's article. The next story Matsuda tells is the story of the weather forecasters. In Kahakwa versus Friday, James Kahakwa, George Kitazaki, and Donald Plummer brought a Title VII claim against their employer, the National Weather Service in Hawaii. They alleged age discrimination, and Kahakwa and Kitazaki alleged race and national origin discrimination. For ease of discussion, I'll focus on Kahakwa, who is also the focus in Matsuda's article, and talk about Kitazaki as his claims overlapped somewhat with James Kahakwa's claims. James Kahakwa was born in Hawaii. He was American. He was of Hawaiian, Irish, Norwegian, German, and Japanese descent. He had a Bachelor's of Science from the University of Hawaii, had served in the U.S. Army for 20 years as a ballistics instructor, and then as Chief Meteorological Supervisor at Schofield Barracks in Hawaii. He was a communications specialist at the Hawaii National Weather Service office and had recorded weather broadcasts. He, his two colleagues, and others applied for a weather service specialist position, which would involve providing weather forecasts. The meteorologist in charge selected an outside Caucasian candidate. Kahakwa and Kitazaki applied for another position when it arose several years later. They were two of the three finalists for the position, but again not selected. As to their Title VII claim, they claimed part of the reason why they were not selected for the position was their Hawaiian Creole English accents. Here the claimants treated accent and dialect as interchangeable, as did the court. And I'll talk about that in just a second. According to Professor Matsuda's telling, Mr. Kahakwa spoke standard English with a Hawaiian Creole accent. So now that these terms have come up, it's worth discussing what they mean. Accent in simplest form is how we pronounce words. Dialect, essentially, is a group's variety of a language. There are actually many dialects or varieties of American English that are grammatically, linguistically correct. Standard English, or Standard American English, is one variety of American English. It tends to be what's used in professional communications, but is not necessarily what's spoken most of the time by most speakers of American English. The district court ruled Kahakwa and Kitazaki's use of Hawaiian Creole English was not based on race or national origin, but rather a result of their economic status, environment, and education. A white candidate was selected instead of Mr. Kahakwa, according to the district court, because he had better diction, better enunciation, better pronunciation, better cadence, better intonation, better voice clarity, and better understandability. This was appealed to the Ninth Circuit, and the Ninth Circuit bypassed that issue to skip to whether the National Weather Service had provided a legitimate, non-pretextual explanation for its employment decision. So if you recall back, that's the second step of the court's process as to employees and employers. The Ninth Circuit recognized the district court's ruling that Kahakwa and Kitazaki were not selected because of their comparatively lower verbal skills, not because of their accents. Further, the Ninth Circuit decided there was no showing of disparate impact against those of Japanese, Hawaiian, or Polynesian ancestry based on the selection process simply because the sample size of 6 candidates who had applied was too small to show disparate impact. There's more in Professor Matsuda's piece, but these are 2 cases that I see from the piece as are key to the law. From these cases, what forms is the idea that accent ties with national origin and perhaps some other characteristics. However, employers can assert something about communication being necessary to the job and be deemed credible by the court and win in court. Before we move on to how all of that fits into current law, I want to highlight one quote from Mr. Flagrante's case, the first case. Listeners stop listening to fill in the blank, accents. What's problematic here is the court seems to acknowledge that there's bias in the listeners, but it doesn't really address that further. And in Mr. Flagrante's case, the burden of that bias was placed on him, the speaker. So I want to address further that confluence between accent and bias. Implicit bias is a concept that's gained more traction in the law in the last decade or so, but I think informs a lot of what may be happening in some of these cases in which employers critique an employee's accent. According to Jerry Kang, implicit biases are attitudes and stereotypes that are not consciously accessible through introspection. Another phrasing is that implicit bias is a psychological process in which a person's non-conscious racial beliefs, otherwise known as stereotypes, and attitudes, otherwise known as prejudices, affect her or his behaviors, perceptions, and judgments in ways that she or he are largely unaware of and typically unable to control. Putting that together, that means even individuals who actively reject negative racial stereotypes can nonetheless be influenced by biases of which they're not even aware because they've been inured to stock stories. Thus, implicit bias can influence decision-making, even where decision-makers think they are being fair and unbiased. I think this can apply to national origin and accent as well. So now we have Title VII, which was intended to create good, but imposes a heavy burden on those it seeks to protect. We have cases interpreting Title VII as to national origin and accent, which ties those concepts together, and those cases have some force. And we have the stories of those most affected, the employees with accents who lost those cases. I want to tell you about one more case before we move on to broader issues. Ioha versus Architect of the Capitol. Now, I did not represent Mr. Ioha as Professor Matsuda represented Manuel Fragrante. However, stories are embedded in the law, and I want to bring to light how different narratives can be seen in how judges and courts and lawyers and others construct facts, such as the facts in a case. Sunday Ioha claimed discrimination, retaliation, and hostile work environment in violation of Title VII and the Congressional Accountability Act, which applies Title VII to congressional agencies. This includes the Architect of the Capitol. Mr. Ioha specifically alleged that he was not selected for a supervisor position. According to Mr. Ioha, this rejection was discrimination against him on the basis of race and national origin. In the district court case, in the District of Columbia, the court began its background, which is basically the second paragraph in the case. It's telling you the facts, by stating the plaintiff is Black and of Nigerian descent. That was what defined him most to the court, or what the court wanted readers of the case to see first. This is the Court of Appeals version. Sunday Ioha was born in Lagos, Nigeria. He grew up speaking Eshin, his parents' native language, but learned English in primary school and moved to the United States age 29 in 1995. He has worked in the Architects' Information Technology Division since 2008. So, Mr. Eun was an information technology help desk manager in the information technology department at the architect beginning in 2008. He was reassigned to a project management position in October 2012 as part of a reorganization. So he was in that previous manager position for 4 years. Mr. Eun felt that the reassignment was a demotion and filed an internal claim in February 2013. In June 2013, several months later, a compliance officer at the architect determined that the reorganization was not an established plan, but a way to move those with foreign accents to less customer-facing positions. Partly based on witness testimony that the CIO, the Chief Information Officer at the architect, had made disparaging comments in meetings about employees with foreign accents. In 2014, Mr. Eun applied for a branch chief position, which included support of server and network infrastructure and evaluating and introducing new hardware, software, and technologies. The CIO, the Chief Information Officer, Jay Weidman, who had previously made the disparaging comments, was part of the panel of interviewers, and his Deputy Chief Information Officer, Officer Clark, was responsible for making the selection. Weidman was the most senior person on the panel. There were 2 rounds of interviews. Mr. Eun did not move to the second round. He filed in federal court in March 2015. So I want to point out the timeline, again, in terms of pointing out the burden on folks who want to bring forth these claims. The reorganization happened in October 2012. The filing in federal court doesn't happen until March 2015. In district court, Mr. Eun alleged the Chief Information Officer, the Deputy CIO, and others made comments about the need for people in the department to speak clearly in English, and that they could not understand Mr. Eun, who, remember, was already in a management position and had been working there since 2008. The district court determined that any disparaging comments made by the supervisors were stray remarks that had nothing to do with Mr. Eun's non-selection, especially given that they occurred 2 years before the non-selection. The court said that the alleged disparaging comments did not give rise to an inference of national origin discrimination, but instead suggested that Weidman and Clark, the CIO and Deputy CIO, sought to address concerns regarding effective communication within the department, which is a legitimate concern by an employer assessing a skill reasonably related to an employee's job performance. There's an assumption here. Having an accent means one is not an effective communicator. The district court determined the employer asserted a legitimate, non-discriminatory reason for the plaintiff's 2 non-selections. The court concluded that a reasonable jury could not find the architect's qualifications-based explanation for Mr. Eun's 2 non-selections was pretext for discrimination, and that's where the case stopped, or would have stopped. If that had been where the case stopped, this might have become another stock story, or we might have thought of this as another stock story of a disgruntled employee or an unhappy employee. Mr. Eun, however, had the time and resources to appeal, which allowed for more of the story to come to light. So the appellate court went into more detail as to some of those comments that were about effective communication. The comments included these. An employee testified that Weidman commented multiple times about communication problems reportedly caused by employees who don't speak English as their first language, asking, "What can you expect?" When someone raised a concern about these comments, he replied, "So sue me, we can't have people like that as our first line communicators." The appellate court further included the fact that Weigman in 2014 had called Eun Hee Han into his office to test Weigman's phone recognition software and explained, oh, it even understands your accent. The employer, the architect, argued that it had hired a different individual with a different national origin and accent. And by doing so, it demonstrated a fair interview process. The district court, the lower court, had agreed with that argument, essentially considering different accents as interchangeable and hiring one person with one kind of accent as showing that the employer had no discriminatory intent towards Mr. Eun Hee Han specifically. However, the Court of Appeals said that there was no testimony comparing the accents, and in essence, it was unclear if they were in the same protected class, Mr. Eun Hee Han and the other individual, and bias might have still been present against Mr. Eun Hee Han specifically, even if not against everyone with a foreign accent. And so the Court of Appeals found a reasonable jury could find unlawful bias based on the facts of the case, including the witness testimony about the CIO and deputy CIO's comments about employees of foreign origin, the CIO's interview scores, remember he was on the panel, being part of the basis for not promoting Mr. Eun Hee Han, the CIO's other comments to and about Mr. Eun Hee Han, and those comments being a pattern of discriminatory remarks, or potentially a pattern of discriminatory remarks. The appellate court also acknowledged the EEOC's definition of national origin discrimination as including linguistic characteristics of a national origin group. So that's now in the guidelines from the EEOC. Further, the Court of Appeals noted the employer never alleged, so I'm going to go back for a second. The district court found or determined that effective communication is a legitimate concern by the employer. The Court of Appeals noted the employer never made that argument. They never alleged Mr. Eun Hee Han's foreign accent made him hard to understand or interfered with his ability to perform employment-related tasks. Thus, Mr. Eun Hee Han's Title VII discrimination claim could proceed. So again, pointing out, this is now a stock story that the district court included, that a foreign accent makes you hard to understand. So given those cases, I want to summarize the state of the law to help us in our discussion. There are a few main principles that come out of the law. One, national origin discrimination includes discrimination based on linguistic characteristics. That's part of the EEOC guidelines definition of national origin discrimination and comes out of some of the cases. So, as supported by some of the cases, evidence of discrimination on the basis of accent can support a claim of national origin discrimination. However, this part is still there. Language skills interfering with job performance may serve as a legitimate basis for the employer's action, and that is in the EEOC guidelines as a bona fide occupational qualification exception and recognized in flagrante. So that law, that case, is still, again, not ancient history. But think about this, the interference with job performance assertion tends to be an issue for which the employer gets to form the narrative, the story. And so by examining the stories, we're able to start seeing this and other issues in the law. I also want to point out that accent bias is not limited to Title VII cases or just the law. In March 2021, Nancy Navarro, a member on Maryland's Montgomery County Council, was in a Zoom meeting advocating for her constituents about health policy issues. This is during the pandemic. And as she was speaking, a council employee and a contractor could be heard in the meeting, during the meeting, commenting on her accent, saying things like, I love how her accent comes out, and she pronounces words like she thinks they're pronounced. It's so cute, they said. I think we don't have enough bandwidth in the Wi-Fi to play the video, but I recorded it, so you always have a backup plan. And I'll try to play that for you right now. I'm just going to pause this to note, this is Nancy Nahara. That's what she sounds like. Listen for the accent. Did anybody hear a noticeable accent? And yet she's being interrupted during the Zoom call about her accent and the way she pronounces certain words. Also in March 2021, in an Association of Corporate Counsel Foundation event, one Asian American lawyer discussed how she had collaborated with a client many times on the phone, but when they met in person, the client was surprised to find out the lawyer was Asian American because she had no accent. As the lawyer further shared, she said, well, I do speak with an accent, it just happens to be a Texas accent. Accent bias may also impact other aspects of the law or legal processes. Linguists from Stanford wrote in 2013 about how Rachel Juntel, who was supposed to be a key prosecution witness in the Trayvon Martin case, the case where there was a teenager in Florida and George Zimmerman shot him. Rachel Juntel was widely dismissed as incomprehensible and not credible, though she spoke grammatically correct African-American vernacular English, which is another variety, it's just a variety, it's a correct variety of American English with its own grammar. And finally, positive bias towards accents may also reflect power imbalance in society and potentially outcomes in the law. A May 2022 article in The Atlantic pointed out that a witness for Johnny Depp in the Amber Heard Johnny Depp trial was deemed likable and honest by those listening in on live streams of the trial, etc., because of his British accent. So, what does this all mean? What are some of the issues or problems posed by the current approach that we take in law and society? Well, it means the law views accent as a deficit. It also means the law's current connection to accent and national origin, unpacking something there, may sustain the notion that certain Americans are perpetual foreigners. The law also currently does not acknowledge the variety of American language, including indigenous languages. And it does not address how certain accents may be favored and others less favored. It also means we're not really looking ahead, which is sometimes a failure in law, because initial studies of Gen Z and Gen Z plus or Gen Alpha show that those who are now adults or growing up have greater diversity, including diversity in national origin and language. And so the question I want to have us think about going forward is, what are we passing on to these upcoming generations, and are we giving them an equitable framework to deal with diversity? So what should we do? Professor Matsuda proposed a doctrinal solution. She proposed that courts take a different approach than they had been by asking 4 questions. 1, as to jobs, what level of communication is required for the job? What does the job actually entail? 2, was the candidate's speech fairly evaluated? So she wants to look at the actual process for evaluating the speech as opposed to depending on the employer's stock story about speech and intelligibility. 3 is the candidate intelligible to the pool of relevant, non-prejudiced listeners, such that job performance is not unreasonably impeded. And 4, what accommodations are reasonable given the job and any limitations in intelligibility. Law doesn't currently contemplate accommodations based on accent. Matsuda's approach, unfortunately, has not yet been adopted. And what I want to propose is that we can, as individuals, adopt some approaches and take control of a little bit of the situation as it's arising in society. One set of methods that we might use is to mitigate our biases. For one solution is to mitigate our biases. This is a method that Ann D. Gordon, a professor at Duke Law, proposed for professors when providing feedback to law students. It's a teaching method. But like many teaching methods, I think these methods are applicable to our everyday lives. And so 5 of the steps that she suggests we take include seeking bias education to allow us to engage in a long-term exploration of bias. 2, seeking exposure to those who are different from us, gifting ourselves a multiplicity of stories. 3, cultivating a growth mindset, which is the belief that your abilities are not fixed, but can grow with effort, introspection, and help from others. 4, that we can be mindful of reactions, just simply be aware of them. And 5, we can reduce cognitive fatigue, even though it might be hard in the digital age to do so, so we don't simply react with stereotypes or prejudice. I think we can also do more beyond that. I think we can also ask ourselves some bias interruption questions. This is a technique I use when I'm teaching students. We might ask if we're interacting with someone who we think has an accent, who the person is, who is communicating. We might ask or consider, what are the circumstances of the communication? What are the facts? We might consider, what is the goal of the communication? We might ask ourselves or challenge ourselves to think about, if I am reacting to aspects of the communication, what am I reacting to? We might ask, if I am reacting in a way that impedes this communication, if I'm the one that's impeding this communication, what can I do to mitigate my reaction? For example, can I ask more questions? Can I follow up? And then we might ask, what can I learn from this experience going forward to align with that idea of cultivating a growth mindset? Maybe adopting some, even if not all of these strategies, will help us going forward individually and as a society. I want to end with 2 things. One, a question that one of my really wonderful Gen Z RAs, Tyler Bates, I have 2 really wonderful RAs, research assistants this summer, Tyler Bates and Lily Lee, who are either listening in right now or will be watching from London and Washington, D.C. Tyler asked me, Title VII at core forbids irrational prejudice. Are we saying some things should be accepted as rational prejudice? And I think that's an important question to consider. And 2, thank you for listening, and especially thank you to Liberty for being here. If you have any questions or comments, I welcome them.
I want to take issue with something that was on one of your earlier slides that said progress essentially is made only when it's deemed to be the advantage of the dominant class. I think that disregards all of the struggles to achieve equal rights undertaken by minority groups, the entire nonviolent movement headed by Dr. King and others, and in fact attempts to achieve civil rights through violent means is not something that results in progress only because it's to the advantage of the dominant class. There are other ways to achieve progress other than convincing the dominant class that it's in their interest.
I would agree with you as to nonviolent versus violent means, preferring and in fact deeming as more legitimate the nonviolent means. I think what's being said in that tenet of CRT is that although the civil rights movement made massive gains for society, there's still a lot of interest convergence that has to happen to keep pushing for advancement. And that still continues to be a challenge. I think we agreed earlier that all questions should be directed towards this part of the room.
I have a question about just the general progress. I did my homework and actually read the law review article.
Wonderful.
And so
all 80 pages.
It was 78 pages, yeah. And the first two cases, it was a little bit kind of discouraging. And so it's nice, that article was from 1991, and then you give us this DC Circuit case where they're making some progress. So I was just wondering how you see, is the general trend in a recognition of this issue, or do you think it's still, that was an aberration and we're still kind of, what's your perspective of that?
Thanks for that. I'm not sure it's a complete aberration, but I also really don't think it's a general trend. The vast majority of Title VII cases fail. And a lot of what happens in the cases depends on the court and a lot of other decision makers on the way. Even with the Eun Hee Han case, which I think the DC Circuit made, I do agree with you. I think that circuit court level decision shows progress, but we see that came upon the heels of that district court decision, which still shows that there's some challenges as well. And depending on how the district court judge ends up becoming the district court judge, or the circuit court judges become the circuit court judges, that might have gone different ways. So I think there's still a challenge, but I agree with you. I am encouraged by that case.
Well, what do you mean by failure? My name's Sean Crick. I tend to defend employers that have been sued in Title VII. And it seems to me, 25 years or so, that the vast majority of Title VII claims we get end up getting settled in the process.
Yes.
With the EEOC. I don't consider that a failure. I consider that a pretty effective and economic resolution for the complainant and for the company. So I'm trying to understand what you mean by the vast majority failure.
I think, well, the vast majority are rejected, so they don't actually even end up in settlement. And I think even success or failure depends on perspective. And so one thing that our clinical professors talk about sometimes is how a client might come, an employee or somebody else who wants to sue, might come, and what they want is not actually monetary settlement. What they want is something else. Their day in court, some recognition, or something else. And so to that kind of client, success might look like something different from what we as lawyers might consider success. But again, going back to the idea that failure means the claims themselves are rejected or fall out or stalled. Thank you.
Thank you for the wonderful presentation. When you're talking about the case that was in Hawaii, I think, or the National Weather Service case, do they take into consideration at all who are among the listeners and what the population is? Because it just seems to me that somebody with a Filipino accent out here, everybody would understand them. And that would be a relevant consideration if you're looking at effective communication.
I agree. And that's part of why I thought the case was interesting to discuss here. Hawaii, of course, is a different population than here, but I don't necessarily think that different. And I think the case is concerning in terms of not acknowledging the diversity of listeners. So we do have that line about the linguistic complexity and social complexity of the population. But that's kind of all the court does to acknowledge that. And I think that is a challenge. Now, of note, particularly for both the lawyers and non-lawyers, the Weather Service case, the Ninth Circuit decision, is unreported. And so for the non-lawyers in here or budding lawyers in here, that means that it's not necessarily meant to be used as binding precedent, though there are different court rules or circuit court rules about being able to cite the case when you're arguing for the court. So that also impacts the relative strength of that case. And I should have followed that. Yes.
I'd like to point out, since you mentioned that there are potential lawyers as well as actual lawyers in the audience, that what you've raised here will go directly into our practice. As you know, the majority of my practice, vast majority of it is immigration work. And I've had clients that getting to the point of having a bad English accent would be real progress. I can say no big deal in 12 languages, and I can't say anything else in. But what I've noticed is, again and again and again, is the difficulty that people who are perceived as having accents or bad accents or inability to understand how they are denied services, how they are they deny themselves services. They start off by saying, my English is no good. And they're speaking better English than at least 50% of the people I deal with all day long. They don't have the confidence. And this is, I hate to use the word systemic because it's beyond that. It's something that we really have to be aware of when we're selecting clients, deciding what we can do for them, deciding what really is going on with them. And it goes outside that also. I mean, you happen to know my daughter, you happen to know how she speaks. She speaks the way I speak. Her biological background, genetic background is Filipino. She's been with us since the day she was born. She was pregnant a couple years ago. She was dealing with a new OBGYN on the phone. She walked in and the OBGYN blurted, "You're not what I expected."
Right.
She doesn't coach.
Right. Like the lawyers who are not.
You're not what I expected.
That's valuable. Thank you for sharing. All right, well then I will stop there because dinner's not on me. But thank you again so much for coming. And again, I'll plug that Dean Quizon Villazor has another lecture upcoming here at 6 o'clock. Is that right, Ben?
Yes, I was just going to announce. I know some people joined a little divisive discussion. So this lecture was is the second of 4 public lectures. The third lecture will be here on July 5th at 6 p.m. and the last one will be on July 7th at noon at the Kuma Justicia. And again, if you weren't here when I introduced Professor Han, this lecture has been supported by the Northern Barnard's Unanimous Council. And just in a minute, I'm going to distribute a survey. Please take a minute and fill it out. And thank you again to Professor Han for coming all the way here.
Thank you.
And a big hand for Ben too.